My name's Ed Harris. I'm the Chief Communications Officer at Family Equality Council, and we're glad to have so many of you joining us today for our webinar, An Introduction to Pennsylvania LGBTQ Family Law. I'm going to hand us over to Denise Brogan-Cater, the Chief Policy Officer at Family Equality Council, who will introduce herself and the rest of the presenters, and then we'll get started.
Thanks, Ed. As Ed said, my name is Denise Brogan-Cater. I'm the Chief Policy Officer at Family Equality Council. And on your screen right now should be a list of our other presenters and our email addresses. Kel Wilkinson joins us. They are from Equality Pennsylvania and the Policy Director. I'd also like to give John Daw, who's the Managing Director of Equality Pennsylvania, an opportunity to say a couple of words about Equality Pennsylvania. Equality Pennsylvania is our partner, Family Equality Council's partner in preparing this guide, and we are very thrilled to be partnering with them. John, you want to say a couple of words about Equality Pennsylvania?
Thanks, Denise. As Denise said, my name's John Daw. I'm the Managing Director and also right now the Interim Executive Director of Equality Pennsylvania and the Equality Pennsylvania Education Fund, which is the Commonwealth of Pennsylvania's leading organization advancing equity and opportunity for LGBTQ communities. We provide educational programming on LGBTQ issues, conduct research to understand public opinions, and develop campaigns to build awareness about LGBT individuals and families and our allies and gain support for fairness and equality. We were founded in 1996 as the Center for Lesbian and Gay Civil Rights, and in fact, one of our other panelists who you will be introduced to shortly, Tiffany Palmer, was the center's, one of our center's early legal directors back in the early 2000s, and us helped the Equality Pennsylvania Education Fund secure second parent adoption rights, which I think we'll talk about a little bit later. In 2010, we changed our name to Equality Pennsylvania Education Fund and have worked tirelessly over the last few years to advance equality through inclusiveness and public policy initiatives. We've worked to prohibit discrimination in executive employment and state contracting, working with Governor Tom Wolf in issuing a gubernatorial executive order. We've established we've worked with the governor's administration to help establish a work group in Harrisburg, which includes representatives from more than 15 executive agencies and departments who meet regularly to identify better ways to serve LGBT residents, share resources, and discuss common issues, and really help ensure LGBT inclusivity in state-provided and state-related services. We've worked to promote access to affirming health care, modernize birth certificate policies, adopt gender identity workplace policies for state employees, and be generally inclusive within state government. So we're pretty proud of the accomplishments that we've made over the last few years. I should also mention that our sister organization, Equality Pennsylvania, which many of you may be a little bit more familiar with, is the political voice for the LGBT community in Pennsylvania. Don't want to spend a lot of time on that, but we do a lot of legislative work and also candidate work and endorsements. So anyway, enough about that side. We are really excited to be partnering today with Family Equality Council on the publishing of the new Family LGBT Law Guide and presenting today's webinar. So I'll toss it back over to Denise.
Thanks, John. So Family Equality Council's mission is to ensure legal and lived equality for LGBTQ families and those who wish to form them. And we do that through building community, changing hearts and mind, and driving policy change. And one of the ways that we help to educate is by publishing these types of guides around the country, and it's always our pleasure to work with such good partners as Equality Pennsylvania, who do the hard work on the ground of advancing policy change for LGBTQ families and those who wish to form them. But after we do the research and the writing of these guides, we always reach out into the community and find a lawyer, an attorney who lives in the state, who is experienced in LGBT law and experienced in family law and the issues. And today we are proud to have join us Tiffany Palmer, who is an attorney with Journer and Palmer PC. And Tiffany graciously provided her time to us to review the law guide that we're going to go through today and give us her point of view and edits from the perspective of a practitioner on the ground. And Tiffany is going to do a lot of the presentation today, so we're really happy to have her. Also, you should just know that you can download the Pennsylvania guide at the address that's on your screen, and we'll put this address up again when we get to the end. I do want to just say that the family law guide is not intended to be legal advice, and today's webinar should not be construed as legal advice. It really is more an overview of the current state of LGBTQ family law in Pennsylvania. The law changes all the time, it changes quickly, and it's important to always consult an attorney or contact us, one of the authors, to discuss the details of any particular situation, and also to ensure that the information that you're reading or we're going to talk about today is still accurate. I can't emphasize that enough, and I think we will probably mention that more than once during the course of today's webinar, but it's always important to reach out to a lawyer about any particular legal situation. So with that, we're just going to jump right into the contents of the guide. As many of you know, marriage equality is now the law of the land, but it wasn't always so. In the mid-1990s, Pennsylvania, along with many other states, reacted to the news that Hawaii's High Court had determined that denying same-sex couples access to marriage violated the state's constitution by passing a statute or a law that defined marriage as a, quote, civil contract by which one man and one woman take each other for husband and wife, end quote. Well, in 2014, the case arose called Whitewood v. Wolf, which struck down that case. The federal court heard the case and ruled that that particular state law that I just read to you, prohibiting marriage between same-sex couples, was unconstitutional. The governor announced the next day that the Commonwealth would not appeal the decision, and as such, Pennsylvania began issuing marriage licenses to same-sex couples on May 21st, 2014. And it wasn't until next year, in June of 2015, that nationwide recognition of marriages for same-sex couples came when the United States Supreme Court ruled in a case called Obergefell versus Hodges. Obergefell not only requires that all United States issue marriage licenses to same-sex couples, but also requires them to recognize marriage licenses issued in other states. So regardless of where you're married, your marriage is now recognized in Pennsylvania. And of course, you can get married in Pennsylvania, and you have been able to since 2014. Some states have separate statuses called civil unions, in some cases domestic partnerships. Pennsylvania does not have that and has never had that, but Pennsylvania has done something really terrific that not all states do, and that is that the courts have recognized civil unions that have been entered into in other jurisdictions as marriage equivalents for purposes of divorce, and that's a really big issue. There are other issues around marriage that we're going to let Tiffany talk to us about. So with that, again, I'll introduce you to Tiffany Palmer, and Tiffany, we're glad to have you, and please take it away.
Thank you so much, Denise, and thanks for giving that overview of some of the background that led to marriage equality in Pennsylvania. And basically, since May 20th, 2014, individuals and attorneys in Pennsylvania have been working hard on recognition and implementation issues of full marriage equality. And the civil union case is one example where previously people who were in civil unions were unable to dissolve them. And now with a Superior Court case that was issued last year, those unions can now be dissolved on the same basis as marriage. That being said, though, individuals who have civil unions with a partner that they're currently with should consult with an attorney as to their validity here in Pennsylvania and recognition by the federal government, because civil unions are not considered marriage equivalents in all areas. So it's important, if individuals want to access all of the many rights, benefits, privileges, obligations of marriage, that if they have a civil union, that they should consult legal advice. The other issue I wanted to address is another big implementation issue with respect to marriage equality is the common law marriage. And a lot of people have a lot of misunderstanding about what it means to be in a common law marriage. And some of the myths I just have here on screen is I've heard a lot of myths such as, common law marriage is automatic if you've lived together for 7 years, that it's been abolished and it's no longer available, and it's not available for same-sex couples if the common law marriage was entered into before the marriage equality decisions that Denise spoke about earlier. So those actually are all untrue. So what is common law marriage in Pennsylvania? It requires an exchange of words in the present tense to be married or live life as a married couple, but it doesn't necessarily need to be public. Some couples did have public commitment ceremonies, holy unions, had actual weddings where they didn't have an actual marriage license or piece of paper, but they did have some sort of public ceremony, and that's really great evidence if someone wants to prove that they had entered into a common law marriage prior to marriage equality being recognized in Pennsylvania. Another requirement would be a constant cohabitation and reputation of marriage. Individuals who are claiming that they have a common law marriage should have had cohabitated with one another and held themselves out to the community as spouses, as a committed couple. And while common law marriage generally in Pennsylvania was abolished as of January 2005, common law marriages that were entered into prior to that date are recognized and grandfathered in. So the ability to access the benefits that would come from a common law marriage, it would have had to be entered into before that date. So you could see the conundrum that creates for same-sex couples, because marriage equality didn't come to Pennsylvania until 2014, and we're talking about recognizing a same-sex marriage that would have had to have been entered into before January of 2005. And so that case actually just came before the Pennsylvania Superior Court just this past April. And the court had to consider this issue: is it possible to enter into a retroactive common law marriage when obviously the two people who were entering into this common law marriage before 2005 knew that legally their marriage was not recognized by Pennsylvania and was not recognized by the federal government. So the case that came before the Superior Court was a case called In Re Stephen Carter. And if we could just have that next slide. Oh, there we go. And it was an appeal of Michael Hunter. Michael Hunter was the surviving spouse of Stephen. They met in 1996, and they exchanged rings with each other on that day in Christmas of '96. And they lived together continuously as a married couple would. They had jointly purchased a home. They attended community events together as a couple. Their friends and neighbors saw them as a family unit. And then sadly, Stephen Carter died in a motorcycle accident in April 2013, which is obviously almost a whole year before they could actually get a marriage certificate. So the problem was that his estate, was being probated, and Michael wanted to claim, this is my common law spouse, so I should be treated the same as a spouse would with respect to the rights that come along with legal marriage. And one of those important rights in this case was the inheritance tax rate that's assessed. And in Pennsylvania, the inheritance tax rate for a non-family member is fairly high. It's 15% of the total value of the estate. And that's regardless of the size of the estate. So it really impacts all different kinds of people, even of moderate means. So it's a very large tax hit when someone's already lost a spouse. So that was then later determined to be 0%. And he won the case, and the court affirmatively decided he could enter into a common law marriage as of the date that they exchanged their rings. Just to give you an idea of how some of these common law marriage benefits can really be helpful, especially to long-term LGBT couples. And our firm has represented clients in both the estate context and the divorce context. I just talked about the inheritance tax rate, reducing that from 15% to 0. And in many cases, that has resulted in a tax refund for our clients who had previously already paid that 15% tax. They're now getting those back in tax refunds by submitting a court document that says they had a common law marriage. The other benefit would be intestate inheritance, basically saying they have the right to inherit automatically, even if the decedent did not have a will. And a couple of other big benefits are government benefits like Social Security survivor benefits. And of course, there's also pension benefits where a spouse may be eligible to get a pension if they were legally married, but not if they were not. So that's where that has been helpful. In the divorce context as well, equitable distribution, which is the division of property, marital property that's accumulated from the date of the marriage until the date of the separation, is another big issue. Alimony and spousal support and Social Security benefits, again, is another major benefit for someone who has been in a long-term relationship where these benefits might not be the same otherwise. And I will get to the next slide here. So I'm just going to give you an example of how this may play out for long-term couples of Jane and Mary. They had a religious wedding ceremony in 2001. They ended up getting an actual marriage certificate right as soon as they were able to in May of 2014. They had 2 children, where each was a biological mother of 1 child. One person had always been the wage earner of the family, and Mary was a stay-at-home mom. So she had 14 years of no employment outside the home and not paying into Social Security. They're now separating and divorcing, so you can see what the situation might be for this family if they were looking at only the date when they had the marriage certificate versus the date when they actually had a wedding ceremony, which is 2001. And we'll just move on to the next slide here. So you can see the difference here. If they're divorcing with a 2.5-year marriage, alimony would be unlikely. The division of the marital estate assets would only include assets accumulated during the marriage, which would only have been 2.5 years. So things like retirement accounts, that can be really different. And then upon retirement, the stay-at-home parent would have no Social Security benefits on the wage record of the wage-earning spouse. If they're divorcing with a 16-year marriage, if we look back and they have a retroactive common law marriage of 2001, alimony is likely. The division of the marital estate looks at all the assets accumulated over 16 years, and Mary, as a stay-at-home spouse, would be able to claim Social Security benefits upon her retirement on the wage-earning record of Jane, because the marriage would have to be in excess of 10 years in order to do that. So it can mean a huge financial change, especially for long-term couples. Now I'm just going to kind of switch gears a bit. That's just a little bit of information about implementation of marriage equality as it relates to same-sex couples and retroactive common law marriages. So I'm going to talk now about children and parentage. And there's 2 basic paths to LGBTQ people bringing children into their lives and becoming parents. The first is through assisted reproduction options, which is where individuals are achieving a pregnancy in a medical or non-sexual procedures, such as alternative insemination, in vitro fertilization, surrogacy. Typically, LGBTQ families are often working with third-party reproduction, meaning that they're working with egg donors, sperm donors, surrogates, or even sometimes embryo donation. So those are just some of the examples of assisted reproduction options. And adoption, of course, is a process where a child is born into one family and then placed, and new parental rights are formed between the adoptive parents and the child, and they become the full legal parents to that child. And there's many different types of adoption. There's step-parent adoption, second-parent adoption, kinship, foster to adopt is another option, international adoption, domestic adoption, and private placement type adoption. And these are all potentially available and possible in the state of Pennsylvania, and that's not the case everywhere across the country. So with respect to adoption laws in Pennsylvania, which I'll just talk about briefly, and then I'll move on to the assisted reproduction issues, which are somewhat more complicated. In Pennsylvania, LGBTQ families may adopt a child as a single person. An out LGBTQ person should be able to adopt, a kinship adoption and agency adoption. There's no barrier for an out LGBTQ person to adopt as a single person. Additionally, there's no barrier for couples, and that means married or unmarried. You know, one of the things that I've heard a lot post-marriage equality is people having the misconception that they have to be married now in order to adopt. There is no prerequisite or requirement that a couple be married in order to adopt, and there's many different reasons that people choose to marry or not to marry, and that is not a barrier to adopting. There may be other hurdles that the couple has to face if they are an unmarried couple. You know, if they're doing a second parent adoption, they may need to do a home study, where if they're a married couple, that home study process may not be required. But certainly there is no statute or legal barrier to a couple married or unmarried adopting. And that has been the case since the Pennsylvania Supreme Court decision in RBF and RCF in 2002. So now I'm going to just move on to talk a little bit about the assisted reproduction options. So there's egg or embryo donation, and this can be from a known individual or anonymous. Sperm donation from a known individual or anonymous. Co-IVF typically is a process where two individuals both play a biological role in the conception. Typically the eggs from one individual are used to create embryos and then transferred to the partner of that person, and the other person then carries that child in their uterus, and they would be a gestational parent, but not necessarily not the genetic parent, because the partner of that person is egg was used to conceive that child, so they would be the genetic parent. Then there's gestational surrogacy, and that's typically where a woman agrees to carry a child for other individuals, but has no genetic connection to that child. So again, that child was conceived through embryo donation or is genetically related to the intended parents, but is not related to the woman who is pregnant. And traditional surrogacy is sort of the opposite of that. That is where a woman agrees to carry a child for other people, but she is actually genetically related to the child, and it is her egg. So an intended parent is a term that's used in assisted reproduction a lot. And it's a person who wants to become a parent and uses some form of assisted reproduction to conceive. And an intended parent may or may not be genetically or biologically related to the child they are conceiving. And a parent who is not genetically related to the child will then have to take legal steps to ensure that they are not just an intended parent, but an actual parent in the eyes of the law. So they need to move from being an intended parent to a legal parent. And a legal parent is someone who's legally recognized as the parent to the child. They have rights of custody, child support. They have the right to make medical decisions for that child, educational decisions and well-being, pick up and drop off, all of those things that are involved. They have automatic custody rights. They are also financially obligated to support the child. And then there's also the rights that come along with that as being next of kin, inheritance rights, and being assessed at inheritance tax rates available for parent and child. And then the government benefits that come along with that as well are typically one of the most important ones is Social Security survivor benefits, that if that legal parent were to die, then the child would be able to access the survivor benefits of that parent. And this is why ensuring that someone is considered a legal parent is so important, because these things are all really high stakes things that could be in jeopardy if someone's legal parentage is challenged. One of the biggest developments and questions that we get post-marriage equality is, especially with respect to same-sex cisgendered female married couples who have a child together, where one is the biological parent and she's married, and her spouse automatically now the other parent to that child? And this comes from what's called a marital presumption of parentage. And in Pennsylvania, this comes as what's called a marital presumption of paternity. And what it is it's a legal fiction that basically says a woman born to a married couple is the legal child of the husband and the woman who gave birth to that child. And most of these presumptions and statutes and how it's risen through case law are all in very sort of heteronormative terms and assume a biological parentage as the backdrop. And it varies significantly from state to state. Sometimes it's statutory, sometimes it comes out in case law. And in some states, the presumption, this marital presumption, can be rebutted by showing that, quote, the father was incapable of physical reproduction, that he is sterile, or that there is no genetic connection to the child. So a lot of these cases come up when a man's name is on a birth certificate, but he is actually not the genetic father to that child, and then his rights are, he's usually challenging his rights to be removed as a legal parent. And in some instances, that actually has happened. So how does this potentially apply to same-sex couples? There is no court order, there is no court decision in Pennsylvania that has applied the marital presumption of parentage to a same-sex couple yet. We've certainly had it come up and arise in cases at the trial court level, but it certainly is an issue that is being currently litigated and challenged, and we do not have a definitive answer on that, and we do not have a statute in Pennsylvania that would govern that with respect to same-sex couples who use assisted reproduction. So how does an intended parent become a legal parent? One of the first ways is automatically, often through genetics, that a person who's genetically related to a child, either by contributing the egg or the sperm that resulted in the conception, is already a legal parent unless there's something else that says otherwise, like a court order or a contract or some other consent form. But this is where a person automatically is a parent, typically if they are related to that child through the contribution of the egg or the sperm. The other way, I mentioned earlier, is how does an intended parent become a legal parent? Through marriage. Again, this is at risk, and this is something, we do not recommend that same-sex couples rely solely on the marriage. And this is typically because marital presumptions apply, and here, especially if you have an LGBTQ couple where they're using third-party reproduction, so there's some kind of donor involved in the equation, that means that one person is going to be left out of the genetic relationship, and that's the person whose rights are at risk. So if there is a physical impossibility of reproduction without a third party involved, that's where it goes. So I talked briefly before about how a genetic birth parent is automatically the parent. I want to talk a little bit about birth certificates. Married LGBTQ couples, both spouses will be listed on the birth certificate in most states, and this is also true in Pennsylvania. But it is not necessarily a legal determination of parentage for the non-genetic parent. Again, that's the person whose rights are at risk. So I mentioned that two married people's names can be on the birth certificate, even if they're a same-sex couple at this point because of marriage equality. But what is a birth certificate? And birth certificates under the law have been determined to be an administrative record of what the birth mother reports at the time of the child's birth. And oftentimes there's cases that have developed where it can be changed or amended in the future if the information that was reported is determined to be incorrect. So one of the main reasons it's determined to be incorrect is because of a lack of a genetic connection or DNA testing that would show that person does not have a genetic relationship. So it took about a little time to implement, but as of May of 2016, the Department of Health did issue a memorandum to all hospitals that requires birth certificates to be issued in the names of both parents if a child is born, and they use this terminology, same-sex married female couples. But of course, this also applies to couples where one individual is transgender if they are not genetically related to the child, and it involves the conception through donors and they are married to one another. So it specifically does use gender language, but we would presume it would apply to individuals who don't necessarily identify as female either. So it's basically if someone gives birth to a child, that person may list their spouse as the parent without requiring a paternity acknowledgement, and then they will file the birth certificate reflecting the names of two legally married. And it does say female in their memorandum, but I would just say it would apply to any married parents without requiring submittal of a court order. So that's great news because that means both people's names can be on the birth certificate. But what we found is sometimes that gives people a false sense of security that that is actually a legal determination of their parentage, and it's certainly evidence that could be used that they're a parent, but it is not conclusive. And so we recommend a different process for people where one person does not have a genetic connection. And of course, the biggest risk to this, and where a lot of these cases come up, is divorce. So if a couple separates and their rights to the child is based solely on the marriage, they're at risk of losing their parental rights when that marriage is potentially dissolved or their parentage is challenged in a divorce proceeding. The other potential problem is all of the fact that the laws across the country are not uniform. There's 50 different states and 50 different ways that courts can analyze who's a parent, and legal parentage is governed by state law, and what law applies to who is the parent is going to be the law of the state that has jurisdiction at the time the question is raised. That may not be the same state where the child was born or where the child was conceived. Typically, it's where the child has lived for the previous 6 months. So someone could feel comfortable and safe having a parentage law in one state, but when they move and that is questioned later, there could be a dispute over parentage. And just to give you an example of some of the differences, and I practice in New Jersey and Pennsylvania, so I use this example. New Jersey has what's called a donor insemination statute, and again, it's written in very heteronormative terms, and it also requires the supervision of a licensed physician with the consent of her spouse. If a wife is inseminated with semen from a man who's not her husband, the husband will be treated as if he is the father. So that's great, and it has been applied to be gender neutral to LGBTQ families. However, Pennsylvania does not have that statute. In fact, Pennsylvania, with respect to donor insemination, has no statute at all. So we are left only to case law to determine how this plays out, and we do not have any case law that directly addresses this issue of parentage for a married couple in this context. What we also have in Pennsylvania with respect to couples who want to conceive using gestational surrogacy, we don't have a statute on that either, but we do have a Superior Court case that was issued in May of 2015 that I was involved in, which holds, and this was the Sherry Shepherd surrogacy case, which did hold that assisted reproduction contracts, and in this case it was a gestational carrier contract and an egg donor contract, that those are legally enforceable contracts. So that's good news for people who want to use surrogacy in Pennsylvania, because those contracts that people enter into are legally enforceable. And I just want to touch, again, note that the best way for LGBTQ couples who are using assisted reproduction to protect their children and to prevent any kind of future challenge to parentage and all those rights and benefits that I spoke about that go along with legal parentage is that if they are married, they should file for a kinship or a step-parent adoption. And the procedures vary from state to state, but Pennsylvania does permit these types of kinship step-parent adoptions and typically do not require a home study, and they can be done very efficiently in all counties in Pennsylvania. And this is, again, this is advisable even if both of those people's names are already on the birth certificate. The adoption decree can protect that non-genetic parent. So I wanted to just note, how does it protect that parent? The U.S. Supreme Court actually addressed this exact question a year after the Obergefell case in 2016 in a case called VL versus EL. And in this case, the biological mother was challenging the rights of the non-biological mother in a same-sex custody case where they were trying to challenge essentially the adoption that decree that was issued by a different state, and saying that the adoption decree should not be recognized as part of their divorce. And so with respect to this, the court said affirmatively adoption decrees have to be recognized in every single state. Even if the couple is now in a state that wouldn't have done that adoption in the first place. Further, they are permanent court orders. They can't be changed or undone in the future, and they ensure protection in the event of custody and child support claims later. So they are critically important to have that adoption decree. It travels, it's recognized everywhere, and that comes from the U.S. Supreme Court, so we know that is something that's not going to change anytime soon. And that, I think, concludes the parentage stuff. So I think I'm turning it over now to Kel.
That is correct. Hi, all. This is Kel Wilkinson, Policy Director with Equality Pennsylvania. I see that we only have about 20 minutes left, so I do want to make a quick comment. If you have questions and you would like to follow up with us afterwards, you can reach us at webinar@equalitypa.org. There's also should be a chat menu on your screen. You're welcome to ask questions there, and we will respond as we can get to them. So thank you very much for participating. All right, so we're going to switch gears a little bit and talk more broadly about non-discrimination protections as it exists. So currently there are no federal or state laws that prohibit discrimination against LGBT people in employment, housing, and public accommodations. However, it is important to note that here in Pennsylvania, we do have 44 municipalities, including 5 of the most populated cities that have non-discrimination ordinances that do protect in areas such as employment, housing, and accommodations on the basis of sexual orientation, gender identity, or both. So on in other areas where people can be protected in terms of employment, let's talk about that. So again, there's no explicit federal law that bars discrimination. However, it is good to know that the definition of sex has been interpreted by some courts to provide employment protections for LGBT people. So for instance, there's case law under the Title VII of the Civil Rights Act where sex has been defined in a way, you may have heard about discrimination through sex stereotyping, for instance. So we have had examples of the Equal Employment Opportunity Commission hearing and investigating complaints of employment discrimination on the basis of sex around this broader definition. Other places where you can see employment protection. So of course, many employers have company policies that prohibit discrimination against LGBTQ employees in application or hiring and other processes. So it's always good to sort of check and consult your existing HR policies, probably in some sort of manual. As another example, Governor Wolf actually signed 2 executive orders in April of 2016. The first prohibits discrimination against state employees on the basis of sexual orientation, gender identity, or expression. And the second one also protects Pennsylvanians who work for companies that contract with, subcontract with, or receive grants from the state. So now I'll talk about housing a bit. So again, you know, in Pennsylvania, we do not have housing protections. There has been some guidance that has come out in the federal government with the Fair Housing Act, as well as the Department of Housing and Urban Development, also known as HUD, that may provide some protection on the basis of sex. Here in Pennsylvania, we don't have that. However, it is important to note that the Pennsylvania Human Relations Commission does have proposed guidance that would categorize sexual orientation and gender identity as a form of sex discrimination. So it can offer some recourse for LGBT individuals who are discriminated in a housing transaction in a place where they might not be protected through local law as well. Again, so on public accommodations, again, we do not have federal law that explicitly protects folks on the basis of sexual orientation or gender identity. Again, here is another case where the Pennsylvania Human Relations Commission's proposed guidance would be an area where people could seek some recourse if discriminated against in a public setting. All right, and now I'll talk a bit about changes of name and gender. So in Pennsylvania, a legal name change requires a petition to be submitted to the court. An applicant then must have fingerprints taken and publish a notice in 2 newspapers citing the name change, though in some cases this can be waived and those records sealed to protect the individual. Then on a birth certificate, you can request for a gender marker change on your birth certificate. A recent Department of Health procedure change removed the surgery requirement to change the sex on a birth certificate, but you do still require a letter from a physician, so an MD or a DO, stating that the applicant has completed or is in the process of a gender transition. Similarly, with a driver's license, if you want to change your gender marker, you do need a licensed medical or social service provider to complete a form verifying the applicant's gender identity. In terms of minors, so minors may request an amended birth certificate, well, rather parents would, but so a parent must complete that application and indicate which sex should appear on the birth certificate. It is important to know that both legal parents must sign that application. The parent's signature must be in presence of a notary, but no medical documentation is required in these cases. All right, and with that, I think I turn it back to Tiffany to talk about legal documents.
Tiffany, are you on mute?
Oh, sorry, yes. I just wanted to mention some of the documents that people may want to consider having in place with respect to even if they're married or if they're unmarried. If you're unmarried, some of these may be even more critical and important. So first is the last will and testament. Now, one of the big changes post-marriage equality is that now with respect to same-sex married couples or LGBTQ married couples, a spouse is automatically next of kin with respect to things like if someone died without a will for what's called intestate succession. However, having a will in place, even if you are married, is important because this is where you could name someone to be an executor. You could name a backup as to who would get your property. If you died, or if you and your spouse died together, how your property would be divided. Some of the other documents related to estate planning that are also important is an advance directive for health care, also called a living will, and sometimes with that is a healthcare power of attorney. And this is the legal document where you can name an individual to make legal decisions for you in the event that you were unable to make decisions for yourself, and also make decisions regarding end-of-life decision-making as to if and when and how life support would be ended if it resulted in a serious permanent condition and terminal state. The other document would be a power of attorney for financial management, where someone could name someone to make financial decisions for them if they were incapacitated or unable to make decisions for themselves. And that's important because if someone is in the hospital or incapacitated, they have the ability to pay their bills, to do their taxes, to file a lawsuit if they were injured in an accident. So all of those things could be done if there was a financial power of attorney in place that would automatically name someone to do those things in case an incapacity occurred. Another potential document is called a standby guardianship nomination, and this would be where a parent can nominate someone to care for their child if they become incapacitated or if they die, and that person could automatically step in to make decisions and take custody of that child without there being a period of time where there's a question as to who has that authority. It's especially critical if a parent has some kind of medical condition or illness to be able to make that nomination for their child. A domestic partnership agreement, another type of document, and this post-marriage equality, this really is about unmarried couples who are living together. If a couple who is planning to marry wants to enter into a contract, then it goes under a completely different set of rules, and that would be a prenuptial agreement or a premarital agreement. And we've seen some problems arise with this because there's different rules that apply for premarital agreements and domestic partnership agreements. And one of those things is that the individuals cannot have the same attorney representing them in drafting that agreement for a premarital agreement. And with respect to premarital agreements, these can actually be useful, especially for long-term couples that are now going to be formally marrying one another, because it can actually help protect their financial interest in assets that were accumulated even before the marriage if there was a long period of cohabitation. And a co-parenting agreement or intended parents agreement is another thing that people may want to consider, especially if people are using assisted reproduction to conceive a child, or if individuals are entering into a co-parenting arrangement with more than two parents. This can be a really important document to protect the rights, especially of the person who is not genetically related with respect to any future custody claims. And I think with that, we can turn it over back to Denise.
Yes, thank you. Thank you very much. Thanks both to Tiffany and to Kel for walking us through this guide and the importance of the various issues that face LGBTQ families in Pennsylvania. Again, as I said at the outset, you can download a copy of the guide from our website following the link on here, and I believe that John said you can also download it from Equality Pennsylvania's website. If you have any questions, please feel free to email them to webinar@equalitypa.org, and we will follow back up with you. And with that, I think we are done. I'd like to thank everybody for attending. I'd like to, again, thank our panelists for presenting, and we look forward to working with you in the future.
Thank you.
Thank you, everyone.
Thank you, everyone.